Assalamualaikum warahmatullahi wabarakatuh. I am Alifa Alia binti Muhammad Taufik, metric number 1233401, and today our group, which is Group 3, will present an article review entitled An Analysis of the Implementation of Suluh in Matrimonial Property Claims Involving Real Estate in the Malaysian Sharia Court. The issue of matrimonial property often arises within Islamic family institutions, especially after divorce or the death of the spouse. These disputes usually involve conflicts over property ownership, particularly real estate, which can be complex and time-consuming to resolve. In this regard, the suluh mechanism was introduced as a method of dispute resolution through negotiation in the Sharia court. It serves as an alternative to litigation as it is faster, more cost-effective, and encourages amicable settlement between disputing parties. This article examines the implementation of suluh in matrimonial property cases, including issues that arise during the process and suggestions for improvement to strengthen its effectiveness. Therefore, this article review will evaluate the article based on its objectives, methodology, findings, as well as its strengths and weaknesses. Next, I pass this to the next presenter.
Assalamualaikum. My name is Ainul Safia binti Muhammad Hafiz. My metric number is 1231571. So today I will discuss about division of joint property in the state. Stated, marital property is the right of husband and wife in a marriage because they both work to acquire property, whether indirectly or indirectly. This is right to be claimed by hers because it will be transferred to them if the owner passes away. So Saleh Buang in 1998 say that even though that the status of marital property is still considered part of Malay customs, it is given a position in the law. So based on the enactment of Johor, Melaka, Perlis, Pening, Sabah, Terengganu and the federal territories, marital property is a means of property acquired jointly by husband and wife during the marriage in accordance with the conditions set by the law, Islamic law. So the property is acquired during the marriage if there is a contribution, either directly or indirectly. So the form the husband and wife in obtaining it. Therefore, inherited property and property acquired before the marriage are not considered marital property. Property acquired before the marriage but which is developed during the marriage is also considered marital property. So the category of property in other parties have slight difference. Which is have firstly, if carry property is property owned by a man that the acquired either while still single or property given to him by his mother. If a divorce occurs between husband and wife, then all the property must be returned to his clan, man only, especially if the husband passed away. So does that mean the wife is not entitled to the property even though it is become her husband while he was still alive? Okay, so the second is acquired property refers to asset that a woman owns before marriage her husband. She may have gotten this property either of a gift or through her own effort before the marriage. So the husband can only manage the property but does not own it, as the ownership right still belong to the wife. So in the case like this, if the couple divorce, the husband has no right to claim to the property. Instead, the property will be given to the daughter from the marriage. If the couple does not have a children, the property should be handed over to the woman's family. So next is the suluh approach is one of the preferred and encouraged method to solve dispute between husband and wife, particularly in matter of property dispute where actual ownership cannot be proven. All explanation or claim can be presented during the suluh negotiation, but in the term of tolerance, it is more important to maintain the existing relationship. So before the judge decide any punishments, it first begin with suluh negotiation. So the suluh negotiation can solve dispute over the ownership of marital property acquired during the marriage. So we can see in section 58 of the Federal Charities Islamic Family Law 206 provides that it is a legal mechanism to ensure fairness in dividing the property that a husband and wife have accumulated during their marriage. So based on the case that have been decided, joint property can exist in the following the three situations. First, property acquired together by husband and wife during a marriage is valid according to the terms set by Islamic law with their joint effort. Second, property acquired together by husband and wife during the marriage, it is valid according to the terms set by the Islamic law with the effort of only one party in the marriage. And the last situation is asset owned by one party before the marriage that have been mostly in charge during the marriage and valid according to the terms set by Islamic law, either by the other party or through the joint effort of the husband and wife. So next is the factor considered by Sharia court in deciding the share of husband or wife in joint property from mutual effort of the parties, as stated in the provisions of section 120(22) subsection 2 Selangor Enactment 203 are the first, the extent of contribution made by each party in the form of money, property, or work to acquire house asset. Second, any debit owned by other parties that were undertaken for their mutual benefit. And the third is the need of any underage children from the marriage, if any, and subject to those consideration of the court should be an equal division. That's all for me.
Okay, thank you for Ainu Sofia. Okay, so today I will continue our presentation. Okay, my name is Muhammad. Before I present my part, I will introduce myself. My name is Muhammad Ammar bin Azizi. My number matrix 1231501. Okay, my part is the position of suluh under the Sharia Court Civil Procedure Act or enactment and advantages of settlement through suluh. Okay. Firstly, the article explains that the implementation of suluh in the Sharia Court is supported by a legal framework. The main provision governing suluh in under section 99 of the Sharia Court Civil Procedure, also known as ETMS. This provision allows parties involved in a dispute to resolve their issue through negotiation at any stage of the court proceedings. This shows that suluh is not merely an informal method of settlement, but it is recognized legal process within the Sharia court system. Through this mechanism, parties are given the opportunity to reach a mutual agreement without having to proceed with a full trial. Furthermore, the article highlights that Section 99 is supported by other relevant provisions, particularly under Section 94 and Section 131 of ETMS. Section 94 provides that any settlement reached between the parties can be recorded by the court, and such settlement may operate as a res judicata, meaning that the same matter cannot be brought again before the court. Meanwhile, Section 131 allows the court to issue an consent judgment based on the agreement reached by the parties. Therefore, the provision demonstrates that the agreement achieved through suluh have legal recognition and can be enforced by the court. Okay. Apart from the statutory provision, the implementation suluh is also strengthened through several guidelines and regulations, such as the Sharia Court Civil Procedure, suluh rules, practice direction, the suluh work manual, and the code of ethics of suluh officer. Okay. The first advantage is that Suluh provides a faster and more cost-effective solution compared to the litigation. Throughout Suluh, parties do not need to go through a lengthy trial process involve detailed evidence submission, witness examination, and other formal court procedure. Therefore, it helps to reduce the time and financial burden faced by disputing parties. Okay, secondly, Suluh promotes confidentially. Discussion conducted during the Suluh section are private, and matters discussed cannot simply by use as evidence in court proceedings. This creates a safer environment for parties to communicate openly and find solutions without fear of affecting their legal position. Thirdly, Suluh helps to preserve resolution. Thirdly, Suluh helps to resolve the relationship between the parties, since the settlement is achieved through mutual agreement rather than a judgment imposed by court. Both parties are more likely to accept and comply with the outcome. This is particularly important in disputes involving family relationships or ongoing interaction between parties. Okay, in conclusion, the article successfully demonstrates that Suluh is an important dispute resolution mechanism that has a strong legal basis and contribute significantly to the effectiveness of the Sharia court system. Although the article provides a comprehensive explanation of benefit of Suluh, further improvement through the empirical studies, case analysis, and discussion of practical challenges would make the article more critical and academically stronger. Okay, thank you. That's all from me. Okay, I will pass to the next presenter.
My name is Siti Umairah binti Muhammad. My matrix number is 1231517. Now I will explain about the approach of Suluh in resolving harta sepercarian. So let me begin with the legal framework. Based on the authors, in Malaysia, harta sepercarian cases which refer to jointly acquired property between husband and wife during marriage must first be referred to the Suluh Council at the registration stage. This is based on Practice Direction Number 1 of 2010. Once registered, a Suluh notice is issued to both parties to attend the Suluh Council at a fixed date and time. In terms of jurisdiction, the Syariah High Court has the power to hear and decide harta sepercarian claims involving both movable and immovable property as stated under Practice Direction Number 6 of 2006. This is further supported by Section 421 Clause A of the National Land Code 1965, which recognized orders made by the Syariah High Court on less vetting, giving it the same standing as orders made by the Civil High Court. Research has also shown that Suluh dominates the resolution of harta sepercarian disputes in selected states, as noted by Nur Husairi in 2014. This confirms that Suluh is not merely an alternative, it is the primary mechanism used in resolving these cases. So now let's move to the second slide. The Suluh work process has been standardized across all Sharia courts in Malaysia through Practice Direction Number 7 of 2015. This practice direction provides a comprehensive flowchart that covers the entire process, from the registration counter, case assignment to the Suluh officer, action taken for successful, failed and absent cases, right through to the reporting stage and preparation of the draft consensus judgment order. Technology is also fully utilized through the e-Sharia system, specifically the Suluh module, which help manage case distribution and documentation. Now, the Suluh officers plays a very important role in making sure the Suluh Council runs smoothly. To do do this effectively, a Sulu officer must have a strong understanding of Hukum Syara, that is Islamic law, as well as statutory law, and must also possess good communication skills. In practice, the session begins with both parties presenting their respective claims and view before the Sulu officer. The statement of claim is used as the main basis for discussion, and the Sulu officer ensures that only matters relevant to the case are discussed while guiding both parties towards a resolution. Last, from my opinion, I suggest the article should provide more Malaysia-specific empirical data on cases where parties fail to attend the Sulu Council, specifically for harta sepercayaan claims. That's all from my side. Now I will pass to another person. Thank you, Umairah. Hi everyone, my name is Siti Maisarah binti Muhammad. My matrix number 1231528. I will continue with how the discussion is conducted in the Sulu Council and how the settlement agreement works. Before the discussion begins, both parties must produce documents related to the disputed property, most importantly, the land title deed. This is necessary to determine the ownership status of the land involved. The extent of each party's contribution is also discussed as part of the agenda to clarify their respective ownership rights. One key point here is that the discussion in the Sulu Council is not as detailed as formal court testimony. Instead of focusing strictly on provide ownership rights, the emphasis is on compromise. Both parties are encouraged to find a middle ground. In some cases, the disputed property may even be substituted with monetary compensation or other movable asset depending on the agreement of the parties. Once an agreement is reached, the list of the assets accepted as harta sepercayaan is confirmed by mutual agreement first, before the respective share of each party are stated. The use of the word voluntarily and the signing of the settlement agreement are considered as element of reda, meaning mutual consent in Islamic law. There is also an approach where disputed assets are transferred to third parties, such as the party's children, as a gift, as noted by Nurul Huda Sahari in 2015. This ensures the property remains intact without needing to be sold. Once the settlement agreement is signed and recorded as a consent judgment ordered by the Sharia Court, it becomes binding on both parties and can be enforced. Importantly, based on Practice Direction No. 5 of 2006 as a Sulu agreement that conforms to Hukum Syara and has been recorded cannot be withdrawn or appealed. Now, let me bring into two cases that support the point discussed. The first case is Tauran bin Abdul Hamid versus Junaida binti Isa 2012. In this case, a settlement agreement was reached to include assets that had been left out from the original harta sepercayaan claim. What is notable here is that both the plaintiff and the defendant had already passed away at the time. Despite the trial judge assessed the condition for the validity of Sulu and confirmed that those conditions had been satisfied. This shows that Sulu is flexible enough to resolve even complex situations that might otherwise be difficult to handle through formal litigation. The second case is Hawa binti Embong versus Ahmad bin Muda. In this case, the Terengganu Sharia High Court rejected the harta sepercayaan application because the plaintiff failed to prove the case to the required level of certainty, known as Zan al-Ghalib, under Section 72, 73 and 74 of the Terengganu Sharia Court Evidence Enactment 2001. This case clearly highlights the advantage of Sulu because, unlike formal court proceedings, Sulu does not require strict formal evidence. This makes it a simpler, less costly and less risky method of resolving disputes. Sulu provides a structured yet flexible mechanism for resolving a harta sepercayaan claims in Malaysia Sharia Court. It is supported by clear legal provision, a standardized work process and relevant case law that demonstrate its effectiveness in practice. For my suggestion, I like to highlight the need for a clearer fairness mechanism in Sulu agreement. Since Sulu does not require formal proof like in court proceeding, there is a risk that the term agreed upon may not be fair for the weaker party. For example, someone who isn't fully aware to their legal rights So the guideline on solo officers informing parties of their legal right before the agreement is signed should be made clearer and more detailed. I think that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Ain Syazwani binti Muhammad Razali. My metric number is 1233406. Next, I will present the author's suggestions for enhancing the implementation of suluh in matrimonial property case. The first recommendation is to enhance the competency of suluh officers. According to the author, JKSM and the State Syariah Judiciary Departments should continue providing professional training for suluh officers. The training should not only focus on communication, counselling and conflict management, but also cover Syariah law, land law, procedural law, ICT and mediation skills. The author believes that competent suluh officers are better equipped to facilitate negotiation and help the parties reach fair agreements. I agree with this recommendation because the effectiveness of the suluh process depends greatly on the competency of the officers conducting the season. The second recommendation is to standardize the procedures for consent judgment and judicial review. The author suggests introducing clear and consistent guidelines to ensure that every consent judgment complies with both Sharia principles and legal requirements. In my opinion, this recommendation is important because standardized procedures can minimize consistencies in the court practice and strengthen public confidence in the Sharia court. The third recommendation is to strengthen public awareness of suluh. The author recommends promoting suluh service through social media, electronic media and print media. In addition, the Sharia court should collect feedback from court users to evaluate and improve the quality of its service. I believe that increased public awareness will encourage more people to consider suluh as an alternative method of resolving matrimonial property disputes. The final recommendation is to expand online suluh service. According to the author, online suluh can make the process more accessible for parties who live far away or are unable to attend court physically. It can also save time and cost while reducing the problem of non-attendance. However, the author emphasizes that clear guidelines are needed to ensure confidentiality and the validity of the online proceeding. Overall, the author concludes that these recommendations can improve the effectiveness of the suluh mechanism by strengthening the competency of suluh officers, standardizing legal procedures, increasing public awareness, and expanding the use of online suluh service. In conclusion, based on our review, this article successfully achieves its research objectives by providing a comprehensive discussion on the implementation of suluh in matrimonial property disputes. The use of statutory provisions and judicial cases strengthens the reliability of the discussions. However, the article could be further improved by including more empirical evidence and comparative analysis to support its arguments. Overall, we believe this article is a valuable reference for understanding the role of suluh in strengthening the Malaysian Sharia court system.
Now we will discuss the strengths of this article. First, the author successfully linked the legal framework with actual court practice effectively, making the article valuable from both academic and practical perspective. Second, the use of court cases such as Tauran bin Abdul Hamid versus Junaida binti Isa and Hawa binti Embong versus Ahmad bin Muda helps readers understand the difference between the suluh process and formal trial proceedings, as well as the advantage of suluh in terms of more flexible evidence requirements. Third, the author clearly explained the role of the e-Sharia system and Practice Direction No. 7 of 2015 in standardizing the suluh process, demonstrating that its implementation is supported by a systematic administrative infrastructure. Fourth, the author explained that a suluh settlement that has been made a consent judgment cannot be withdrawn or appealed under Practice Direction No. 5 of 2006, thereby affirming legal certainty within the suluh mechanism. Fifth, The author effectively highlights the role of SULU in reducing the burden of Sharia courts by shortening dispute resolution time and minimizing litigation costs. This demonstrates the practical efficiency of SULU as an alternative dispute resolution mechanism that supports the broader objective of judicial efficiency. 6. And last one is the article systematically analyzes relevant statutory provision, particularly section 99, 94 and 131 of the Sharia Court Civil Procedure Enactment, and clearly explain the SULU process from referral to consent judgment. This discussion is further supported by the relevant academic literature, which highlights the key strength of SULU. That's all from me. Thank you.
Next, weakness and limitation for this article. First, there is no discussion on the mechanism that ensures the agreement reached is fair for both parties, particularly when one party may not fully understand the legal implications of what has been agreed upon. Second, although the author mentions the knowledge and skill requirements for SULU officers, there is no further discussion on the minimum qualification standards or competency assessment mechanism to determine whether they are sufficient for handling a complex property case. Third, the impact of parties failing to attend the SULU season on the resolution of a matrimonial property case especially is not elaborated in sufficient depth. However, despite its strength, the article has several limitations, which is the author does not discuss whether a SULU agreement always reflects the actual rights of the parties, particularly because the evidentiary process is not examined in detail. This may raise concerns about whether the final settlement is always fair and balanced. Moreover, the article does not critically analyze the consistency of SULU implementation across different Sharia courts, especially in resolving similar matrimonial property disputes. Finally, the discussion is mainly descriptive rather than analytical. The article lacks empirical evidence, case studies, and comparison with other disputes resolution methods such as litigation. As a result, important practical issues including unequal bargaining power, difficulties in achieving mutual consent, and cases that may not be suitable for SULU are not fully explored.